Tonight on Canton Confidential, voicemails from Karen Reed. Her calls to John O'Keefe hours before his death.
Nobody knows what he wants.
And cell phone data pinpointing his last location.
Shows me it's there the entire night.
All this revealed in court today. But the new information calls other testimony into question.
And you would agree with me that chain of custody of a piece of evidence is an important detail in any criminal investigation, isn't it?
Yes.
Tonight, still so much left to be answered. Canton Confidential, the Karen Reed murder trial, starts right now.
An emotional start to today's testimony. Good evening and thank you for joining us. I'm Glenn Jones. J.C. Monahan has the night off. The prosecution is nearing the end of its witness list. This morning, Judge Cannoni approved the addition of 2 new witnesses for the defense. Earlier this week, she heard from 3 potential defense witnesses before deciding if they would testify. This morning, the judge ruled Dr. Marie Russell will be allowed to testify as a dog bite expert, but it will be on a limited basis. Daniel Wolf, one of 2 accident reconstruction experts, also got the okay. Judge Cannoni has not yet ruled on the second crash expert. We'll talk about what those late additions mean for the timeline of this trial a little later in our show. But first, let's dive into today's testimony. We heard from 3 experts for the Commonwealth. Trooper Nicholas Guarino was back on the stand. He testified about GPS information and cell data from both Reed's and O'Keefe's phones. Up next were 2 specialists from the medical examiner's office. Our Kirsten Glavin is live in Denham for us once again with a recap. Kirsten, a lot of critical information for the jury today.
Yeah, Glenn, a lot of data and scientific evidence was presented to jurors throughout the day today. Now, at this point, the prosecution is expected to rest tomorrow, which means the defense will have their chance to challenge it. 8 voicemails played for the jury Thursday morning, many of them angry and laced with profanities.
John, I hate you!
The Commonwealth stating these messages were left on O'Keefe's phone by Reed throughout the overnight hours when O'Keefe died.
John, I'm here with your kids, and nobody knows what the you want, you pervert. Yeah, it's 1 a.m. I'm with your niece and nephew. You pervert.
Mass State Police Trooper Nicholas Guarino stating he extricated data from O'Keefe's phone, mapping out his drive to Fairview Road and his Apple Health data. He argues the data shows O'Keefe never made it inside the house.
We believe we were within about 3 feet of exactly where he was found.
Reed's defense pointing to how the phone captured steps taken and O'Keefe allegedly climbing 3 flights of stairs. Then a dispute over timestamps.
Sir, are you aware that apps on an iPhone may pull data from 3 different clocks?
Next up, a pathologist at the chief medical examiner's office testifying to O'Keefe's brain injuries.
It was something that required some type of force, given that there were skull fractures.
Can they also be consistent with being struck by a vehicle and then going to the ground?
Yes, they can be.
The final witness, the medical examiner, going over autopsy results. The doctor testifying that the cause of O'Keefe's death was due to blunt impact, injuries of the head, and hypothermia. As for a manner of death,
I listed could not be determined.
But she did say she didn't see any signs of a significant altercation. We asked the defense about that outside of court.
So she's going to say, yeah, I didn't really see anything super consistent, but she also can't answer why is there a laceration, why are there lacerations on the nose, why is there a laceration on the tongue, why are both of his eyes black. There's multiple reasons for the black eyes. There's not multiple reasons for the defensive wounds, the laceration on the eye, the eyebrow, the lacerations on the nose and things like that. So the real evidence, the rest of the evidence is yet to come with our witnesses. So just stand by.
Reed's defense attorney Alan Jackson, who you just heard from there, also says that he plans to bring in 2 additional medical examiners to testify differently from what we heard today in court. As far as that medical examiner goes that we did hear from, she will be back on the stand first thing tomorrow morning to wrap things up. Glenn?
All right, Kirsten, definitely on the home stretch now. Thank you. Back here in studio with me now is Sue OConnell, our courtroom insider and commentator. Sue, you told us on this show last week to expect those voicemails to be played by the prosecution. Today, we heard them. What was that moment like in court? Because at home, I have to tell you, it felt dramatic.
Yeah, it definitely was. First of all, you're in the courtroom. For some reason, most people in the courtroom today were wearing dark colors and black, which sort of was a coincidence. Most of the jury was wearing black. And the judge had ordered the AC shut off so they could be heard clearly a couple of voicemails in. And the jurors, you could see, were both captivated, riveted, and really trying to listen. Remember, they don't know what's coming, right? They shouldn't know what's coming. So they don't know how many voicemails there are. They don't know what the content of it was. And remember, we also are in this very controlled environment where the judge controls things. There's not been a lot of fireworks. People haven't been yelling. There's been, some theatrics. But this is something that really happened, and Karen Reed's voice fills the courtroom, and she is clearly distraught. Now, how you take that, that's up to the jurors to decide. But a distraught voice comes on screaming, yelling, profanities. And as we listen to the calls, we can also hear, I think the last voicemail we heard was, "Where are you?" And then we end with the voicemail that we heard weeks ago of the dial that was made that went to John's voicemail with Jen McCabe, Kerry Roberts, and Karen Reed in the car when they come upon Fairview and they get out of the car. So the end of this, the bookend of these voicemails is the trauma of discovering John's body, finding John's body, and Jen McCabe making the 911 call. So it was very intense. A number of jurors were just clearly making faces that it was hard to listen to, and it filled the entire room, and otherwise everybody else was very still and listening to it.
Let's talk briefly about the body language you saw from the defendant. We get so many questions, and a large number of them are about people commenting that they think her demeanor is out of place in the courtroom, sometimes joyful, sometimes laughing and smiling. What was her demeanor while this was happening?
I think over the past week, her demeanor has become more serious than it has over prior weeks. She definitely looks more drawn to me. She looks a little bit more moved by the testimony that we're hearing today. Obviously, I wasn't in the courtroom afternoon, but we did have more autopsy information, which has to be disturbing to everyone. Listen, if it were me, I would be acting differently, whether I was guilty or not. I would be acting more grief-stricken. I would be acting more worried about things. Right. But again, I also know sometimes you have to act authentically. And if this is authentically how she is all the time, then this is how she's acting. So it's going to be up to the jurors to decide if her reactions, if they don't get to hear her testify, her reactions are communicating to her if she has intent and if she did it.
All right, so stay right there. We're not done just yet. Still ahead on Canton Confidential. Conflicting testimony, cell phone data mapping out Karen Reed's alleged whereabouts seem to contradict the timeline previously presented by the Commonwealth. We'll take a look at those details when we come back. We're back now on Canton Confidential, joined once again by our courtroom insider, Sue OConnell, and now Dean at the Massachusetts School of Law, Michael Coyne. All right, folks, the prosecution is nearing the end of its case. More than 60 witnesses so far.
Allegedly.
Good point. And near the end here, we're hearing from a lot of experts. But today, some of the expert testimony seemed to contradict testimony we've heard earlier. Here's part of the testimony we want to highlight, and we'll talk about it on the other side.
By looking at the timeline in the phone, we're able to see that Ms. Reed's phone auto-connected to John O'Keefe's Wi-Fi at his house at 12:36 a.m. We know this because it's a password-protected access to the phone, so you would have to know the password to get into this Wi-Fi network.
And that would be the home in 1 Meadows Avenue, correct?
Yes, that's correct.
Okay, I've been listening closely, and I know that 1236 time code does not match the timeline given by several witnesses in this case about where Karen Reed and her SUV were. Michael, what is the jury to make of this?
Well, it's just another question that the jury will have as to why things don't all add up. And from a government perspective, that likely is going to mean that the jury is going to question whether reasonable doubt exists, because it's the government's burden of proof again. Time and time again, every witness we put on opens up more issues and more questions for people. And that's just not where you want to be if you're the prosecuting attorney in this case.
Around this table, Sue, you have been part of the chorus. Get me the expert witnesses. What is the physical evidence? What's the hard data? We've had it over the last couple of weeks, but has it been presented effectively?
Well, I don't know if it's been presented effectively. The problem with the data, which I have now learned, is that there are loopholes in everything. And the prosecution and the defense, depending on what they want to say and what point they want to make, are able to point to the loopholes to either make their case or attack the other case. Look, I've had an Apple Watch. I've had an Apple phone. Sometimes my Apple Watch tells me I've gone up 12 flights of stairs and I've been sitting on the couch. Sometimes my phone tells Uber that I'm over there when I'm over there. And so what we heard today was a bunch of technical and scientific evidence that I don't know what to believe or what not to believe, not because they're being evasive, just because it seems to be less reliable than I expected to be. And it's the same for the defense. I mean, this doesn't change. So the timeline, right? So the Wi-Fi sign-in. Well, did the storm affect the Wi-Fi like it affected the GPS? Am I not to believe that she didn't sign into John's Wi-Fi at 12:36? Was Jen McCabe confused about what time? Was she was actually looking at a clock in the kitchen? So it's just all very confusing, and it's not giving me the fundamentals that I would need in order to decide if it's helpful or not, so maybe I don't pay attention to any of it.
Well, let's talk about two expert witnesses that we expect to have conflicting testimony. We heard from Trooper Joe Paul earlier this week, who testified that the SUV likely struck Mr. O'Keefe. But we now are going to hear from Dr. Marie Russell, who will tell us that the injuries on John O'Keefe's arm likely came from an animal, probably a dog. I wonder, Michael, if there is a pathway for the jury where both things can be true, and perhaps these two witnesses aren't conflicting in their testimony, but might be saying two parts of the same story.
Well, I think you're going to find that they do conflict. And what we have to remember is that experts are offering their opinion. They weren't there. It's not there's some factual basis, but at the end of the day, it's because of their training and experience, they can offer their opinion as to what it is. And that's all it is. And so, yes, it's possible that both things could be true. He could have been brushed by the vehicle, knocked to the ground, and then at some point a coyote or some other scavenger animal may have come upon the scene. That seems highly unlikely. The problem is that if these bites are in fact what the expert will now testify to, that those injuries that we've seen, and really the only injuries we've seen, are more consistent with a dog bite than being brushed by the vehicle, then again, the prosecution has likely provided that reasonable doubt that certainly some of the jurors are looking for at this point.
Let me ask you quickly before we move off this subject. Do you feel that the judge got the ruling correct about allowing Dr. Russell to testify specifically about animal bites?
I do. And I think on the whole, I think she's done a terrific job guiding the ship down the middle of the road. I bet when this is over that the defense lawyers will say that they feel that they got a fair trial before Judge Cannoni. And I think Attorney Lally would as well. At the end of the case, they're not going to say it now. She's been equally abusive to both sets of lawyers at times to try to move this thing along.
All right, and another quick question for you, Sue, because I know you get so much feedback on social media, and the injuries on John O'Keefe's arm are a major point of conversation. So let's go to this viewer question who wants to know, has anyone asked whether the scratches on John O'Keefe's arm could have come from a wild animal, like a coyote, some animal that might have been out there in the snow?
Yeah, well, to Michael's point that he just made, I can imagine that someone might want to forward that idea. But again, at this point in the trial, introducing new ideas of what could have happened is not going to really help either side, I don't think. Like, sure, anything could have happened. We're pretty clear about that at this point.
But do you know? Do you feel like you know what happened?
No, I have no idea what happened. And whatever opinion I had last week is different than the one I had the week before, and different than I had the week before. And it's just really confounding to me that we just don't have a narrative.
All right. Sounds like a difficult pathway from that to justice. I don't know. All right. Thank you both. Just ahead, the Karen Reed murder trial shedding light on the behavior of lead investigator Trooper Michael Proctor. Tonight, the NBC 10 investigators are digging into his training and the investigation into his handling of this case. That's all new when we come back, first at 7. Let's talk about the lead investigator in the Karen Reed murder trial. So many of you certainly are. He's been in the spotlight for his conduct in this high-profile case. Tonight, NBC 10 investigator Kathy Curran is digging into Trooper Michael Proctor's background, his training, and potential consequences if he did indeed cross the line.
This is another stain on the Massachusetts State Police, and there could be serious implications for Proctor himself. Proctor took an oath back in 2014, and now 10 years later, experts say his actions and admissions in this case may have betrayed the badge.
Would you please state your name and spell your last name for the jury?
Trooper Michael Proctor.
State Police Trooper Michael Proctor on the witness stand reading some of the vulgar texts he sent from his private cell phone to family, friends, and fellow troopers about Karen Reed, the woman accused of killing her boyfriend, Boston police officer John O'Keefe.
She's a whack job.
Proctor was a member of MSP's 81st Recruit Training Troop, graduating in 2014. He's seen here on a training run at the academy. State police records obtained by the NBC 10 investigators show he's completed thousands of hours of training throughout the years, including smartphone forensics, fair and impartial policing, investigative techniques, and crime scene. Since joining the Norfolk County District Attorney's Detective Unit in 2019, Proctor's completed even more on digital cell phone forensics and homicide investigations.
I think any rational person, trained or not, would know that this is inappropriate behavior.
Defense attorney Doug Lewison has represented law enforcement in criminal and civil cases across the state for decades.
The fact that he was the lead investigator and felt so unrestrained in his language shows a stunning lack of judgment, and it shows a lack of supervision. It shows a lack of someone jumping in and saying this is inappropriate. And that trickles back to the first night he showed up on that scene. As soon as he became aware of who was involved as witnesses, he should have stepped back and said, I can't take this case.
Testimony has shown Trooper Proctor was familiar with some of the key witnesses in the alleged murder. Several investigations have been launched into the handling of the case. Multiple sources tell us an ongoing federal investigation opened the door to Proctor's personal texts, that the state's Post Commission, which certifies police officers, is monitoring the case, and an internal investigation by state police is underway.
These are unprofessional comments, but they absolutely do not detract from the integrity of the investigation.
The department has rules, regulations, and policies that include organizational values, code of ethics, unbecoming conduct, bias-based policing, dissemination of information, and telephone use.
In a law enforcement professional's career, that testimony was devastating.
Retired State Trooper Todd McGee says Proctor's behavior doesn't reflect the behavior of most troopers, but what's been exposed may have violated the oath that's supposed to be upheld.
The conduct is clearly egregious. Conduct must always complement the department and must always be in the highest regard to, in a sense, protect the name of the state police. There are probably 3 or 4 different areas that have been revealed that could trigger violations.
The Norfolk County DA's office tells us Proctor is still performing his normal duties. His conduct raises possible Brady List concerns that could prevent him from testifying in future cases. State police have no comment, and we never heard back from Proctor's lawyer. Kathy Curran, NBC 10 Investigators.
If you're looking to read the Proctor documents Kathy mentioned, you can find them right now on our website. When we come back, Michael Coyne returns to the table. His thoughts on those Brady List concerns. Our legal analyst, Michael Coyne, is back with us. We should talk briefly after that report from the NBC 10 investigators about Michael Proctor. Has his conduct injured this case, do you believe? And what are the ramifications going forward from a legal and investigative standpoint on any case that he touches?
I think his conduct has significantly injured this case, and the prospects of the government getting a guilty verdict on these charges. And that's really unfortunate, because if she is not convicted of these charges, the likelihood is no one else will be charged in the future.
And going forward?
And going forward as well, in my opinion. And also what you've got now is he hasn't just damaged this case, but he's likely damaged any other one that he's been principally involved in the investigation, because now you've got disclosure issues. Under the Brady list, prior bad acts of police officers have to be disclosed by the district attorney to the other side because it's considered exculpatory evidence. As Kathy pointed out, you've got the Post Commission that is going to look at whether the police officer should remain certified as a police officer, and if not, he cannot be a police officer going forward.
Okay.
Your governor knows your name. You've got all other sorts of issues that people have come out with. It's really damaged not just the cases he's worked on, but his future career.
All right, Michael Coyne, thank you so much. That's all the time we have tonight. Testimony resumes tomorrow morning at 9. This is Canton Confidential, the Karen Reed murder trial.